Hi. So, just to introduce ourselves, I'm Sarthak, and Akriti, why don't you introduce yourself?
Right. I'm Akriti. I'm an observer at LSPR.
Yeah, we're both students at NLS, and this is part of the podcast we're doing for the queer column that Law School Policy Review recently launched. So, what we do in these podcasts is that we call scholars who worked on issues of gender and sexuality. And for this podcast, we've called you, and why don't you give a brief description of your work for our viewers?
Yeah. Hi, Sarthak and Akriti. Thank you for inviting me. This is I'm right now in Maryland. I teach in the department of it's called the Harriet Tubman Department of Women, Gender and Sexuality Studies. I'm an assistant professor here. I joined last semester after completing my PhD from the University of Minnesota. Sorry for looking at groggy and all. It's morning here, and yeah, so apologies for that. But I hope we have a great conversation. In terms of my work, basically, what I am primarily concerned with is so my primary method is ethnography, and the primary question is that when violence is not one of exceptional event, but it is what constitutes the everyday, then how is life made? And I do that work with trans communities in India, primarily with trans communities in West Bengal. And of course, that ethnography is also informed by the way the law has the way the law produces constructs the idea of transness, or not simply transness but also queerness, and how law also becomes a part of everyday lives. So even though the ethnography is primarily set in West Bengal, but it has larger ramifications in the way how the macro becomes a part of the micro, if that makes sense.
Yeah. Thank you for that, Professor. So we'll just start with the first question. So your paper, The Transgender Nation and Its Margins, just to set context for everyone listening before we get into all the questions, you extensively talk about the problems, and in your general work as well, the problems with the Trans Act and the law in India in general. So for our viewers to set some context, could you give a brief rundown of the problems with the Trans Act and what you think the problem is with the current legal structures in India for queer individuals?
Right. So that paper came out in 2019, and it was when I was writing it, one of the challenges of doing work in around anything contemporary is that things are happening constantly, and things happen much faster than an academic paper can ever encompass, because an academic paper has a long drawn process. It goes through multiple reviews, and then it comes out, and by the time it comes out, it might even become a little dated. So that paper uh, was actually also encountering that problem, but it still, I think, has relevance, because the problems that I tried to bring up in that paper continue to exist. So in 2014, we know that the Supreme Court issued its historic verdict in Nalsa, right? And one of the central premise why that verdict was historic is that it enshrined the right to self-determination of gender, right? And so irrespective of whether one seeks medical intervention or not, one could identify with the gender that one, felt most comfortable with. Now, when it came to the Trans Act, it really watered down that very radical idea. So and even then, but it's very important to also study the way trans communities across the country have staunchly protested against the Trans Act. So before it became an act, it went through multiple iterations as bills, right? And so my paper actually details the various iterations of the bill. So one of the first versions of the bill actually stated, like, it completely did away with the idea of self-determination, and it had these district like screening committees which would be constituted by medical professionals who would basically examine whether one was a gender fraud, right? Like, in the sense that one would have to undergo medical transition to be able to identify as trans, right? And so um, trans movements have been trying to depathologize gender forever, and here was a law that was actually doing exactly that, that medicine is the only arbiter of one's gender identity. So there was massive opposition to this version of the bill, and so the state did um, step back, but only partially. So what happened with the Trans Act is that it made the process very complicated, almost like a two-tiered process. So if I identify as trans, then I can just get that certification from the district magistrate without having to prove any kind of medical intervention. So while that process seems to be aligned with the Supreme Court verdict, but if one identifies as male or female, then some form of medical intervention will become necessary. So if you identify as trans, medical intervention is not necessary. But if you identify in the binary, which many trans people do, one could identify simply as male or female, then some form of medical intervention will be required. Now, that medical intervention could be hormones, it could be surgery, it could be anything. But there has to be some form of medical intervention, right? So, in that sense, it really steps away from the NALSA verdict. Now, that's only one part of it, right? But the second and more important part, perhaps, is the bureaucratic hazing that happens in the whole process, right? Like the whole process of applying to the district magistrate and then getting the medical certification. That itself is a very complicated procedure. And obviously, when one's identity is marked by a piece of paper, then getting hold of that paper itself becomes a huge challenge. Um, so, for instance, a lot of trans folks might feel very uncomfortable going to the government hospital and getting certain certificates because of the pervasive transphobia. And so they might have their informal networks of through which information circulates, that at a particular district there is this particular endocrinologist who is actually quote unquote trans friendly, and therefore they might be getting that certification from that person. But will the state recognize such a certification of medical intervention? Because it says that it has to be state recognized, right? So there are all these very practical difficulties that makes the process of getting the certificate really very difficult. So that's one on the level of identification. Then the other question was, of course, the question of reservation. Now, the NALSA verdict talked about reservation in education, in employment, and as OBC, as other backward classes. Now, of course, there's a lot of debate around conflating gender and caste, and there have been many robust conversations around that. But at least the question of reservation is very important, especially when from within the communities, a lot of trans activists from the oppressed caste have been talking about horizontal reservation. So there is a lot of conversation about that, like how to really implement reservation when it comes to the question of trans identity. But the Trans Act has absolutely nothing on reservation, and even the rules that have been circulated after the act was passed, not just by the central government, but also across the several other states. None of them really talk about reservations. So in that sense, also the act has really severely watered down the Nalsa verdict.
Right. Thank you, Sayan, for that wonderful introduction to your paper. And actually, when I was reading the paper, I had a question related to the question of representation and how, when the rules were being drafted for West Bengal particularly, when the district level screening committee was formed by the government to affirm gender as an identity, as you had mentioned, these rules were not also the committees were also not completely representative. And if I'm not wrong, there was also this Bengal Declaration by major trans groups, those who actively lobby for trans rights, that they had drafted a series of demands which were known as the Bengal Declaration, and even they were not taken into account by the West Bengal state government. So, how do you think that representation, and like how can we make the district level committee more inclusive at the ground level? How does it representation practically work when you're drafting rules for the state and not just West Bengal as a whole?
So here are a couple of things. Now, when I wrote that paper, the rules in West Bengal were not even circulated, right? So the rules have just been recently passed, like in November of 2022. And so it is very important to remember that under what conditions were the rules even passed. So the act is passed in 2019, right? And then in I think in 2020, when the central government passed the rules. Now, when the central government passed the rules, there was no conversation around the rules at all, because something else was happening historical. Something very historic happened during the time. The repeal of the removal of Section 317 Kashmir happened, and so obviously there was massive agitations around the country around that. But quietly, these rules were also passed during the same time, right? So it just became like not even a footnote. So now the if the central government rules were passed, then it took the West Bengal government so long to pass the rules here. And so recently there was this case filed by Shamragi Bhattacharya, who is a teacher based in Shibpur, Howrah, on the outskirts of Kolkata. So and it was because of her petition that the Calcutta High Court basically stipulated a time period that the certificates have to be issued. So what was happening is that in West Bengal, because the rules had not been really framed, so folks who were applying for the trans certificate and ID through the national portal of trans persons, their applications were pending. So, for instance, if you look at the data, I was just checking the data today. So the National Portal of Trans individuals have received a total of 258 applications from West Bengal, out of which 210 are pending, and only 48 have been issued, right? So the figures are really, really dismal. Now, one of the reasons why the figures are so dismal are because even after I have uploaded my application, I've done everything, the applications get stuck with the district magistrate because there is no clear-cut transparency on how to proceed with those applications. Because the district magistrate is because there have been a lot of confusion that since West Bengal doesn't have its own rules, should it be following the center rules, or should it just be waiting? And so in that process, a lot of time has really passed in the process. So this current High Court judgment actually basically says that even though the West Bengal rules have been framed very recently, but you've had the central government rules for so long. So what excuse do you have for not implementing those rules and going ahead with issuing the certificates, right? So that has been one of the major challenges. So many applications have been pending, right? So that's one. Now, the second thing was what I specifically mentioned in that 2019 paper was um, how the transgender quote unquote development board was constituted in West Bengal. So that was not the district screening committee. That's a very different thing. So the transgender development board was set up in West Bengal, and there were just some very arbitrary consultations that happened in uh, in a couple of hotels in Calcutta, and through informal networks of information, only primarily activists from Kolkata were invited, and activists of Kolkata who had some friends in some districts were invited. So there was no widespread community representation when it came to really deciding on how the board would be constituted. The chairperson of the board is obviously a minister, and so there are state government officials. So even in terms of the community representation, it's really been very skewed in terms of location, in terms of caste, and so that has been a problem. But then some of the trans activists on the board have also tried to intervene over the years, but in terms of whatever limited powers they have been given, they've been trying to bridge gaps with the community and trying to really understand what are the challenges that the communities are facing, but they have no power. Actually, they've never had any power. So because of that, also what is really the mandate of the board has never really been clear, right? And so then what happened is that eventually the board was like, its tenure ended, and then a second board was constituted during the pandemic, and this time there was no consultation. Like, at least in the first, there was some pretense of a consultation, but during the formation of the second board, there was actually no consultation. And again, it was arbitrarily constituted. And again, it's not at all clear who, how, what gets to become the member of the board. And again, some of the members of the board themselves expressed frustration about being in a position which actually doesn't really have any power, right? So that's on the level of the board, which is pretty defunct and doesn't have any power. And then on the other hand are the rules which have just been circulated by the West Bengal government, and hopefully things will speed up now, but it has taken so long. But also what has been very interesting, and this is a very latest development that needs to be marked, is that when the rules were first circulated, a very short deadline of a couple of weeks was given for community feedback, and no extension was given. The community gave extensive feedback, and then what happens is that none of the feedback was taken into consideration, and the rules as they were in the first draft, that is exactly how the rules have been passed without accounting for any of the community-based feedback. So again, like just as the act diluted the Supreme Court judgment, when it comes to the rules also, there is again a focus on medicine and some kind of a stability in terms of identity. So the point that I mentioned about if I access medical intervention in a private institution, the rules do not allow me, do not recognize such a certificate, right? Certification. So that becomes a problem. Then a major problem with the rules is that, and that is also a larger question of how the state really sees the trans identity. So when you apply for the certificate, it has this place for permanent address, right? So you have to give, and that is compulsory. So you have to give like a permanent address. Now, most trans people, because of various safety reasons, could be due to livelihood reasons, they do not have regular addresses, right? Like they don't have stable addresses. So I could flee home because my home is very violent and transphobic. And when I leave home, that means I do not want to give that address as my permanent address anymore, right? I might not want to give the names of my parents anymore, right? But then those are absolutely compulsory fields that you have to fill up. Then with the West Bengal rules, there is this provision that you have to prove that you have been a resident in the place where the district magistrate is located, you have to prove that you have been resident in that district for at least 6 months. Now, that is a very impractical requirement, given the fact that if I am someone who is a migrant laborer, I go and dance at weddings, and I could, from West Bengal, I moved to Bihar and Uttar Pradesh during the wedding season, and I dance there. And so, which means I'm moving around constantly. So I will not be able to I will not be able to prove that I have been resident in a particular place for 6 months. So then, do I not have the right to get that certificate? So these practical questions. So on one hand, tying transness to the natal family, and on the other hand, tying transness to a stable address, right? So this form of stabilizing that the state is doing is really, it goes completely contrary to the question of self-identification.
Right. Right. Thank you, Sayan, for that answer. And concerning, like, as you had mentioned about the late and delayed implementation of the act and of the rules, sorry. So there was also this clash, as you had mentioned in the Calcutta High Court judgment, that the Central Act and the rules, the timing was clashing for the enforcement of the latter. So do you see that as a normal, regular bureaucratic struggle between the central government and the state government? Or is that something which is peculiar, a problem which is peculiar to the trans community and issues that are concerning the community?
I mean, every identity has certain specificities, that is for sure. And we can talk about those specificities later, but largely the bureaucratic problem of the state versus center is not just limited to the trans communities. It cuts across various other marginal identities as well. So if you look at the question of disability, for instance, the central government has this unique identity, UID, right? The unique identity for disabled people, which tries to streamline the whole process so that disabled people have only one card, which will allow them to have access to various welfare measures instead of constantly making copies of every other identity card, which is a very ableist way of imagining how one can access welfare, because like assembling all these papers is very, very difficult. So UID is supposed to be streamlining that process. So now when it comes to West Bengal, we'll see that West Bengal is one of the, and this came up actually, I don't have the latest figures, but in Rajya Sabha, it actually came up where the minister actually said that West Bengal was one of the states with the lowest number of UID cards issued. So as of 2021 October, it was just 9 cards that were issued. I don't know what is the current figure. I couldn't access it yet, but yeah. So even with disability, this kind of a problem is there. The rules of the right of the RPD Act, the Right of Persons with Disabilities Act, even the rules for that was passed very late in West Bengal. So that then you could think about insurance, for instance, Ayushman Bharat versus the insurance scheme that West Bengal has, and how the state government actually opted out of Ayushman Bharat because saying that the West Bengal health insurance scheme was started before Ayush Bharat. So these kind of debates keep happening, but it's interesting to note that Ayush Bharat actually is supposed to be covering gender affirmation surgery, at least on paper, but the West Bengal one doesn't as of now. So this is not to say that one government is more progressive than the other, but what I'm basically trying to make a larger argument about how the clash between different governments actually jeopardize access to welfare for particular groups of the population. And the larger point here is that how our politics has actually become a politics of personality cults. So what happens is that it's not simply a clash between the center and the state. It is the clash between the figure who symbolizes the center and the figure who symbolizes the state. It becomes a clash between two figures, right? So every single scheme has to have the cutout and the figure and the photograph of the chief minister and the prime minister. So it becomes a clash around that. So then, what is the fact that welfare is one's right then gets obfuscated, and it becomes something like welfare is something that the chief minister is gifting or the prime minister is gifting, right? So that is why, whose gift will the marginalized person accept? Will the marginalized person accept the gift of the chief minister or the gift of the prime minister, right? So that is also how this personality cult actually dilutes participatory democracy.
Yeah, thank you for that, Sayan. I think you talked about identity cards for disabled people, and in your paper as well, you talk about how identity proofs are required in both central and state legislations now. So, given that a lot of trans people, especially at a young age, end up fleeing their homes, so what kind of recourse do these legislations provide, if any, and what problems do trans people face while accessing benefits under these legislations because of a lack of identity proof? Could you expand a little bit on that?
Yeah, so it's kind of building on the conversation that we were having just now. It's actually very difficult if one has fled home, because look at the kind of language that is being used, right? So, for instance, if we go to the national portal of trans persons and the national portal of trans persons, you'll see that the language that's being constantly used is rehabilitation, right? So, so the Ministry of Social Justice and Empowerment has this scheme called SMILE, Support for Marginalized Individuals for Livelihood and Enterprise. And now, under SMILE, there is this sub scheme called Comprehensive Rehabilitation for Welfare of Trans Persons. So, what is this idea of rehabilitation? How do you rehabilitate? So if one looks at the Trans Act, it is repeatedly what it is doing is that it is kind of criminalizing hijra households. So a lot of young adults who flee homes because the homes are very transphobic, they could take up shelter in hijra households, right? And the Guru Chela system has been a long for centuries, it's been a very robust kinship system. Like any kinship system, it has some violence, of course. Which kinship system doesn't have violence? But then it has also been providing shelter to these gender non-forming kids. And but the way the state is thinking about the idea of rehabilitation, it is saying that people who initiate young adults into begging will be criminalized. Bonded, it's using language of bonded labor. But begging, which is like in the hijra community, what is called referred to as challa, is a hijra profession. That is not bonded labor, right? So the state doesn't really take into account community histories, and tries to constantly centralize the natal family as the only arbiter of the welfare of the gender non-forming child. So the gender non-conforming child is read as this innocent child who cannot decide for themselves. And if they have fled home, then the state is going to put them in some rehabilitation center. And then the idea is to absorb them back into the home, where the abuse generated. And so criminalize alternate kinship networks. So that is where the act really thinks of transness. So that is one problem. The second problem is, like I was mentioning, right, the permanent address. Like, what is the need for this permanent address? What is the need for this idea of proving your residence over a particular period of time, right? This is constantly, then you just move them towards the permanent home, right? Like you basically endure the violence and stay there, and destroy these alternate, these other robust forms of kinship networks that have been there, that have actually provided shelter against the violent natal family. So that has really been the major problem.
Right. Thank you for that, Sayan. And so you had just mentioned in the previous question that certain bureaucratic issues, they are not completely particular to the trans community or to these particular rules, but they are symptomatic of the broader legislations of the clash between the central government and the state government. So what directs your attention towards these rules specifically, that you wanted to focus on them, the bureaucratic problems that are concerning these rules specifically?
Look at the current budget. Only 6 crores have been assigned for trans communities, right? I think that should say enough about how the state really thinks of transness, right? It's a token. And like any kind of a minoritarian rights claim should deserve attention. And transness is not, trans identity is not an exceptional minoritarian identity, in the sense that it the way it intersects with disability, the way it intersects with caste. So all those factors really are really there. So I wouldn't say that, like when I work with trans communities, it is like some kind of a choice that I made amongst this basket case of minoritarian identities. That's not how things have to, that's now not how one sees things, but it is within the larger framework of how the state itself, on one hand, so it's a very, very interesting paradox, right? On one hand, the state claims to be liberal by constantly invoking that we are doing these rehabilitation projects, we are doing these livelihood schemes, right? And so the prime minister goes to UN and says that we have a very progressive trans act. And so the state uses gender and sexuality to claim that it is a liberal state. But on the other hand, if one really goes into the everyday nature of oppression and how law contributes to that oppression, then one sees that this claim to uh, being a liberal state is only a facade, right? It obfuscates the violence of the state. And that is where it really becomes important to really carefully study what's really going on.
Right. Thank you for that. And another question that I just popped into my mind was related to the Transgender Development Board, which you had mentioned in your piece as well, which was constituted by the government. It attracted a lot of criticism from the community, from the trans community, since it was headed by cisgendered women, and the trans representation was low, and it was low even when those who were drafting the act, they were also not belonging to the community as a whole. So, do you think that, like, bringing in the idea of politics of presence and other ideas, that is this problematic, that there should only be trans individuals who should be formulating the act? Like, should we totally discount cis individuals from the policy making for queer communities as a whole?
See, that's a very utopic question, right? Given the fact that cis people have never really ceded any space to trans people at all. So when no space has been even granted, then how do we even talk about whether trans communities are in a position to remove cis people? They are not. The cis people have constantly relentlessly, deliberately, mercilessly removed trans presence from a framing of laws that really affects trans lives, right? So without really looking at that history, we cannot really account for cis trauma. So that is the first point that I would like to mention. The second point is that when it comes to questions of representation, of course, representation matters, but it's not simply of any kind of tokenistic representation. And what do I mean by that? So, for instance, the state has it constituted a national board, right? I'm forgetting the exact terms. Now that board is the National Trans something. I'm forgetting the exact name. So that board is basically, uh, again, it was very arbitrarily constituted. It is headed by a particular prominent trans activist, who is very close to the current government. And this particular trans activist has earlier made a lot of hate speech against minority populations in the country. And this particular trans person has even claimed that there is no caste within the trans communities. So this particular person doesn't necessarily represent the trans communities as a whole. In fact, trans communities across the country have written open letters denouncing the commentary made by this particular trans leader. So when I talk about representation, trans representation matters, particularly from oppressed castes across different languages. The dominance of North India, for instance, is a problem. So language specificities are very important. Caste specificities are important. But also the larger politics of representation needs to be really understood, right? Like, what does it take to be really close to the state? Right? Does one have to make hate speech against particular minoritized populations to be able to be close to the state is a question that one has to think about. Like, for instance, look at the ramifications of this kind of selective representation. We have now shelter homes across 9 states in India, right? But that now the which are called the Garima Grihas. Now these Garima Grihas have mostly gone to particular states with to particular activists who are close to this particular trans leader. So the process of in which how Garima Grihas were allocated was not transparent. It has like why does the state of West Bengal have two Garima Grihas both in the city of Kolkata? So there is complete lack of transparency on every level. Now, why only 9 states? What happens to the rest of the states and the union territories? That's been a major problem. How were these Garima Grihas assigned has been a major problem. But even then, the Garima Griha, the idea of Garima Griha is very important because shelter homes have been a very like a crying need of the community because there's so many homeless people. People are forced to leave their homes, lack of employment. So those problems have been there. And so Garima Grihas have been important. But at the same time, one notices that for several months, so many Garima Grihas have not been receiving their dues and are almost on the verge of shutting down. So there are just problems on so many levels that sometimes it becomes like every time one has to go to a high court or every time one has to file a petition with the Supreme Court to be able to be heard, because otherwise um, everything is a challenge.
Yeah, thank you, Sayan. We'll just move to the last question now. So we sort of had two questions, but we'll combine them. So in your piece, Inhabiting the State Subjunctively, you talked about how trans individuals are inhabiting space in society and more broadly in politics these days. So to relate to that, the criticism of judgments like Naz, Navtej, Nalsa has been that when they come to the issue of queer rights, they sort of, even though they talk about a lot of things, their impact has been restricted to decriminalizing a very private act, the act of sex. So do you think that even though they talked about a lot of things, like the right to have your own identity or the right to be whoever you are, in their impact they're sort of very limited judgments in the sense that they don't go beyond, in their impact they don't go beyond decriminalizing homosexuality? So do you think this criticism of these judgments is well founded when you look at how trans individuals are these days inhabiting society and politics? So what is your take on that?
That's a very broad question. So the criticism of particularly the Navteej Johar verdict is extremely valid. So first of all, one has to recognize that judgments can only go so far and not beyond, unless it is able to inform everyday realities of one's life, the way one accesses law. Then and that becomes a whole different battle, right? Judgment cannot really change feudal mindsets. It cannot change the fact that caste is what constitutes the social life in India. And one way in which social life is constituted is through marriage and endogamy, right? So So then how do you think of sex without really thinking of caste is a big question. And of course now, and that is where the complicated life of law comes in, right? So a judgment can be very utopic and can be very aspirational, but how that permeates our regular lives is a different conversation, right? So that is on one hand. Now, specifically with the case of the Johar judgment, what is very interesting here to note is that there has been a long 2 decades long legal activism against Section 377. And that activism has had great participation from different sections of rights-based groups. So from feminists to child's rights activists to like it's been across the spectrum. So the way it all started is with the 1994 petition, which was filed by the AIDS Bhedbhav Virodhi Andolan. So if one looks at the work of AIDS Bhedbhav Virodhi Andolan, it was a staunchly non-funded group of people who were working with sex workers, who were working on questions of blood donation, who were working with questions on right to access to health. So there was a strong rights-based, which did not get restricted to sexual identity only. That is the history of the legal activism against Section 377. Then with the NAS petition, how Voices was constituted. The Voices Against 377 was constituted as this loose umbrella group of activists, individuals, parents. Now, what happens when? So then, what was happening with ABVA or the NAS petition was that on some level, it was the community aspiration over the individual, right? But when it comes to the Naftesh Johar, it becomes about celebrities. It becomes about individuals. So a group of celebrities, who like eminent personalities, a celebrity hotelier, a celebrity dancer, a celebrity owner of a restaurant, like multiple people come together and talk about how we have contributed to the nation, but because of our sexuality and because of the way the state has made us criminals. So then it becomes about individuals. And in becoming about individuals, the decades of legal activism that was community generated through acrimonious debates, through conversations, through lots of coming together, departures, all kinds of stuff, that gets invisibilized completely, right? So in some way, individual aspirations become the center. Like even if one looks at the IIT petition in Section 377, even that becomes about merit. So then that question of community, the collective, gets disappeared, and it becomes about individual identity, right? And so that is definitely a problem. So if a particular judgment is about individual identity, then how can it even think of transness and the community problems? And with sexual identity, one has to remember that the state does not simply come and start harassing you unless there are telltale signs, right? If so, one it looks at the histories of cruising, it has been mostly the kotis, the feminine persons, the trans sex workers who have faced the brunt of law. So then, how do you really pull apart sexuality from gender? Who is wearing the it's not the the celebrity figure who is masculine appearing, who's not on the streets getting apprehended by law. So if one really looks at the materiality of abuse, then and even the petitions repeatedly, trans people are being invoked, the or not just trans people but feminine people who are outwardly like non-conforming. And so it's the gender that marks one's sexuality as criminal. But when it comes to the Johar verdict, then that separation happens, that it becomes about individual respectability and one's contribution to the nation. And in that, it marks itself apart from the decades of community activism and the debates that community activism had generated. So that is about Johar. Okay. Now, having said that, one is, and that is where I bring in that question of the subjunctive, that like the hope and the uncertainty, that or the provisional way in which we negotiate institutions. We know that certain institutions are intrinsically violent, but because those institutions are also what sometimes provides us very selective welfare. So there is no other option. We have to engage with those institutions. So if the Naftesh Jauhar verdict has decriminalized, then it has to be used again and again in again accessing law, that okay, this verdict has decriminalized us, so because of that these are my rights and entitlements, therefore I need these, right? So even when one knows that a particular judgment has severe limitations, one still has to um, use it strategically to be able to access other welfare needs. So that is where that the argument about the subjunctive I was making, that we are not outside of the nation state, right? We are not outside of any structures. So then, and we know that the structures are what that are basically invisibilizing us, obfuscating our demands, and not enshrining our rights. But then, how do we negotiate them and push the structure further and further?
Thank
That
you.
is the work of movement building.
Yeah, thank you for that. This was it from us. We don't have further questions, but Akriti, if you have any comments, and Professor, if you have any comments to add about the project in general, if you've had time to go through the queer column, our previous podcast, anything you have to add.
No, I haven't had a chance to go through the podcast as yet, but I've read some of the articles. So, good luck to you, and it's absolutely great that you're doing this work in law, like we have to keep engaging with the law, and we have to keep critiquing it and pulling it apart and building something better. So that work is very, very important. So absolutely, and best wishes to you, and I really look forward to seeing how this goes further, and I hope that I can continue to have more conversations with you all.
Great, thank you,
Thank
Akriti.
you so much, Professor. We loved hosting you, and I loved reading your pieces when I was doing my research as well, especially the one regarding the inhabiting the space subjunctively. So it was really great. It was an honor to host you.
Thank you. Take care.
Thank you.
Bye.
We'll just
You too.
end this. Bye
Bye
bye.
bye. Bye, sir.